Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Mr. Martinez, this is an
Welcome
arraignment
back to
on a
Justice
misdemeanor
Unfolded.
complaint that
Today's
alleges
case
that on
dives
or
deep
about
into
May
the
18th,
unexpected. A misdemeanor charge that might look
2025 at the
small on
location of
paper,
Carpenter
but
Road in
reveals a
Pittsfield Township,
complex
Washtenaw
backstory
County,
behind
State of
defendant
Michigan,
Juliet von
that
Ocean
you
Bear
were in
Martinez. From
possession of drug
confusion in the courtroom to
paraphernalia.
surprising
Do
legal
you
terms,
understand the
this
nature of
hearing
that
takes us
charge, ma'am?
inside a defendant's attempt to navigate the system
Yes.
alone. But when things
That's
don't
a
go as
misdemeanor,
planned,
punishable
even the
by up to
judge
90
steps
days
in.
in jail,
Stick around,
$500 fine
because
plus
what
court
starts
costs,
as a
and any
simple
substance
arraignment
abuse
soon
counseling the court
exposes
deems
a web of
necessary. You
past
understand
cases,
that?
unclear answers,
Right.
and one critical decision
All
that
right.
changes everything.
And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't
Is it
necessary.
necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Miss Martinez,
Yeah.
are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court, a court on any other things?
I am, but none of them are drug related, and they're about to be finished.
Well, maybe. What other courts are you before, Miss Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like have it like
To do what?
have it go, like, is there any way to like forget about this somehow? Is there anything that I can do, like community service or something that could do instead of
Ms. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, knowing a little bit about your history, I don't know that would be a wise call on your part.
I guess so.
This is the turning point. Martinez starts looking for a way out, asking if she can just forget about this or trade jail time for community service. The judge's tone sharpens, making it clear that's not how the justice system works. When the defendant tries to represent herself, the court steps in for her own protection. Judges often walk a fine line here, balancing a defendant's rights with their best interests. And in this moment, we see the real emotion: denial, confusion, and maybe even desperation. Would you represent yourself in a courtroom like this, or let a public defender take over?
Like what? Like, I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like I can have this be adjourned with a bond. Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
Oh.
So,
I'm not protesting to the allegations. I would like to
well,
just,
hold on. I don't want you saying anything about the offense.
well, I do. I see no way around it. It's plain and clear and simple. And
Well,
there's
I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
but it's clear. It's plain. Like, is it really?
Oh, I don't know that, Ms. Martinez.
Yeah, I guess I'll go with a lawyer. Sure.
You will do it. Okay, public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them. So I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that. All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So I believe it's the 28th.
Okay. So what I will do is I'll adjourn this matter out to August 6, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you.
Thank you, Your Honor. Thank you, Ms. Martinez.
Miss Ma'am, it says the Forensic Center is coming to see me today?
In the end, the judge does what's best for the system and for Martinez, appointing a public defender and scheduling the next hearing. The legal takeaway here is clear. Even minor charges can become major complications when they overlap with existing cases or mental health evaluations. This hearing highlights how judges must balance fairness, empathy, and procedure, especially when a defendant isn't equipped to navigate the legal maze alone. What's your take on judges' patience here? Too firm or perfectly fair? If you found this case as fascinating as we did, don't forget to like, share, and subscribe for more real courtroom moments that reveal the human stories behind the legal drama. This right here is where things get real. Antonio admits to snapping someone's headphones, but what's striking is how he calmly acknowledges it, almost as if it were a minor mistake. But legally, it's not small at all. Damaging someone's property over $200 crosses into criminal territory. And when he adds that he struggled with officers, that confirms the resisting charge. Notice the judge's measured tone. She's drawing out each admission carefully to ensure there's no confusion or grounds for appeal later. It's controlled, methodical, and fascinating to watch unfold. Quick question for you. Do you think the judge is being too lenient here or fair considering the circumstances?
Is that what we're doing?
Yes, Your Honor.
Your Honor, the defendant will be pleading guilty to count 3 as charged, as well as adding count 4.
Well, the form doesn't, that's what I'm trying to figure out,
Okay.
because it doesn't say that. But it says the count 4, but not count 3.
Where would I add that?
Anywhere would have been better than nowhere.
You could handwrite that the defendant would also be pleading.
Well, yes, I'll be more than happy
Yes.
to do your job.
I'm rusty, Your Honor. I'm not here.
All right. It's the court's understanding that the plea agreement form that the defendant is going to be pleading to guilty to the stated count 3 of malicious destruction of personal property, 200 to 1,000, the 1-year offense, and also an added count 4 of attempted resisting and obstructing, the 1-year offense. Upon a successful plea to those charges, counts 1 and 2 would be dismissed, And there is a consent by the prosecutor to HIDA. That is the court's full understanding of it.
Yes, Your Honor. Yes, Your Honor, that is the agreement that I have discussed with my client. He would like to accept that offer today.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Antonio Cornelius.
Stated his name. Sorry. All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
No.
Is that your understanding, Mr. Cornelius?
Yes.
Sir, do you want to enter these, please?
Yes.
Are you going to answer my questions then?
Yes.
You understand that you'll be pleading guilty to 2 misdemeanor charges.
Yes. Your Honor.
Counsel approach, please. Record should reflect that we've had a bench conference in the Cornelius matter. I'm going to pass the matter briefly, let him have a conversation with counsel, and then let us know when you're ready and call you back up.
Thank you, Your Honor.
Court does recall the case People versus Antonio Cornelius.
Zachary Wood on behalf of people.
Wow. Was that a sneeze or just a scream? That hurt my ears.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, he stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
All right, and I have had him sworn. And so we were in the middle of a plea, and sir, my understanding is that you wanted to take advantage of this plea offer, is that correct?
Yes, Your Honor.
All right. And you understand that you will be pleading guilty to 2 misdemeanors?
Yes.
All right. First of all, this court's understanding that you'll be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Also, that you'd be pleading guilty to an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, you still wish to plead guilty to these charges?
Yes.
All right. To the charge of malicious destruction of personal property, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not at this time.
Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No.
Anybody threaten you or coerce you in any way?
No. No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of March 5th, 2025, at the location of 2281 Bonesteel Boulevard, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do regarding the personal property of a Jonathan West?
Broke someone's headphones without permission.
Pardon?
Broke somebody's headphones without permission.
Okay, so you got their headphones and you When you say you broke them, what did you do?
Attempted to snap them in half.
Say again?
Attempted to break them.
Just break them?
Yeah.
All right. And you didn't have their permission to do that?
I did not have permission to do that.
All right. And you didn't have any property interest in these headphones, meaning you didn't own them at all, did you?
No intent of theft.
Pardon?
No intent of theft.
He asked if you owned them. Or they were headphones.
Did not own the headphones.
Okay. And these headphones, are you disputing that they had a value in excess of $200?
Yes.
You are disputing that?
No.
Okay, so that, maybe I asked the question badly.
I'm not disputing.
You're not disputing that they were worth more than $200,
Yes.
right? Okay, I just wanted to make sure. At some point, then, did you come into contact with officers from the Ann Arbor Police Department?
Yes, said they were from the Ann Arbor Police Department. They may have had DPSS caps on.
Your Honor, they were doing,
It was U of M.
Yes.
Yes, Your Honor.
So you came into contact with officers from University of Michigan Department of Public Safety.
Yes.
And what happened in regard to your interaction with them?
They grabbed my arm. I struggled after they grabbed my arm.
You struggled with them. They were grabbing your arm to arrest you?
And there it is. The judge accepts Antonio's plea to 2 misdemeanor charges, dismisses the other counts, and schedules sentencing for June 3rd. For those unfamiliar, this kind of plea often comes with reduced jail time in exchange for accountability and cooperation. Antonio's honesty, though hesitant, likely worked in his favor. But this case reminds us, even small acts like damaging property or resisting arrest can carry serious legal weight. What do you think? Should he face jail time or just probation? Drop your thoughts below. And if you found this breakdown insightful, don't forget to like, share, and subscribe for more real courtroom analysis and dramatic legal moments every week.
Yes.
And you struggled with them either to make the arrest of you more difficult or to try to stop the arrest itself or to at least do something to obstruct what they were trying to do.
Yes.
Is that correct?
Yes.
Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas, 2 counts, 3 and 4.
Welcome back to the courtroom, where confusion turns to clarity, and a simple plea deal spirals into a surprisingly tense exchange. Today, we're following the case of People versus Antonio Cornelius, a man accused of damaging property and resisting arrest. But what starts as a routine hearing quickly takes an unexpected turn. Will Antonio's calm demeanor hold, or will his silence and hesitation push the judge's patience to the limit? Let's dive into this dramatic courtroom moment that's got everyone talking. Welcome back to the courtroom, and buckle up, because this one's about to spiral into chaos. Today, we meet Joshua William Wara, a self-proclaimed jailhouse lawyer who refuses any legal counsel and believes he's the target of an Illuminati-led conspiracy. What starts as a simple traffic case quickly descends into wild claims of trillion-dollar thefts, secret government plots, and accusations that even involve Elon Musk and Donald Trump. The judge tries to keep things on track, but Wara's explosive allegations turn this courtroom into pure confusion. Stick around, because this hearing tests patience, sanity, and the very limits of courtroom order.
Delphia Simpson came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got to
Klans.
do something. I've got to
With
do
the
something with your
NDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10
you- if
times
the-
the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can
Okay.
criminally
I
prosecute
got,
to the
no, I'm with you.
extent, which is
I'm
my
with you. I
right.
did that. I did the math too. Listen, here's the thing.
Mhm.
I have to advise you because if you are going to represent yourself, what you're here on,
I'm doing
okay?
it over Zoom because they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
But Pentagon's
in the
using
city of
prism to
Ann
make
Arbor,
the
Washington
Zoom
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount. But since it is conspiracy
Okay.
to murder, sovereign
I'm
law
with
does
you.
not
I
exist.
got you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count
amount.
2 on the complaint that
Legally.
alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of, that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Senator Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I
then
do
all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not
to
a
what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
based
any point you do,
on objective evidence.
if
A
at
bench
any
trial
point
is
you
subjective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I would
Now
like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence,
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law, and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist
if I
because
can
the amount of money that
I
they
don't know,
put
I've
that
not
hit
been
out
very
on
good at
me,
it, but.
and Donald Trump and Elon
Oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get
Okay,
Mack
okay, I'm
and
with you.
Chair.
I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
give
So
Donald
we would
Trump the
need more
elected
time.
chair.
The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Frederick Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't, yeah.
Okay, but you haven't
There's too
seen
many
the
people involved.
You
You have a
haven't
Neuralink
seen
in your brain.
Okay, pause for a second. Did you catch that? Joshua just accused the judge of having a Neuralink implant and being part of a Nazi conspiracy. This is beyond courtroom chaos. It's a meltdown in real time. You can feel the tension shift as the judge stays calm, patient, and surprisingly composed, despite the outbursts. And this raises a huge question. Should judges keep cases like this going, or call for a mental health evaluation on the spot? Because at this point, the defendant's delusions might be overshadowing the legal process entirely. What do you think? Is the judge being too patient here?
And you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
It's
so
based on
listen,
factual evidence. The jury trial
I,
can be
I,
tried.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please, with all evidence. I would like to.
You want to
subpoena
represent
all records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Juarez.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolph Mack, Donald
We're not
Trump,
bringing out those people
Elon
then.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm going to indicate he doesn't want his discovery. Says he doesn't need it. Would they, man, I'm not gonna have the complaint that's rights have been infringed. So yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. No, I have to do no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm going to
Yes.
give you your preliminary examination. So your preliminary
you.
examination will be set in person on,
Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
no, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close, but
with Carol
it-
Conkey in East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She was at 22nd Judicial Circuit Court with Fryer and Ellen Warren and Jeffrey Peak. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm
Fine.
suing for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me
Okay, so here's what I'm gonna
and
do.
Donald Trump.
I don't know that we'll be able to go, given how you're
Yes,
acting.
we will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
I'm gonna set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr.
And there it is. The The judge finally hints at what many of us have been thinking all along: a possible competency evaluation. That means the court will assess whether Joshua even understands the nature of the charges or can participate in his own defense. It's a crucial safeguard in any fair trial, because if a defendant isn't mentally fit, the system has to pause justice until they are. From conspiracy theories to courtroom patience, this case had it all. If you found this hearing as unbelievable as we did, make sure to hit that like button, share your thoughts below, and subscribe for more shocking real-life courtroom moments and expert legal breakdowns. Until next time, stay sharp, stay curious, and stay tuned for more courtroom chaos. Welcome back to the courtroom, where tension meets truth and justice unfolds in real time. Today's docket is packed with drama. From a defendant accused of posting explicit photos online, to another pleading for leniency while juggling school, kids, and court dates. But as the judge digs deeper, shocking details emerge about intimidation, probation, and hidden violations. Buckle up. This hearing is about to expose who's really playing by the rules and who's playing with fire.
AKA the phone.
Again, Your Honor, I apologize. Someone dared call my work cell.
What? Somebody called your work cell? I think it was somebody over there. They just. All right. Okay, what are we doing? Your name, sir?
Jeff Murphy.
Thank you. What are we doing?
Your Honor, discovery is complete in this matter, requesting exam be held.
No. People have their witnesses available the 27th?
Your Honor, if I may have a moment.
Yes.
Your Honor, I do want to bring up something else that's concerning this case, and at this point, I'm hoping that the court can warn the defendant. I'm sure Mr. Burgess will speak to him as well. Part of this case is defendant posting naked pictures of the victim. Not that they should be anywhere, but certainly places that have put her at risk. They have since been taken down, is my understanding. So if the court wouldn't mind issuing a warning to the defendant about ensuring that does not happen again. And I believe Mr. Burgess is well aware of what I would do if this happens again, so he can have a conversation with his client about.
All right. So these came up after the charges in this case?
Let me double check. Your Honor, we don't know the exact date. I have to look into that.
Okay, but they have since been taken down.
Yes, it's been taken down, which is why I'm asking for a warning as opposed to.
All right. You understand that, sir?
Yeah, yes.
All right. And Mr. Burgess, you're going to have a more detailed conversation with him about that?
Yes, I will, Your Honor. I'm well aware of what Ms. Tanner will do if that's the case. If he does it again, if it happens again, if it did happen in the first place, Your Honor. So.
All right. Very good. Okay. And with the people
That's a good date, Your Honor.
that will work.
Thank you, Your Honor.
Preliminary examination in person, May 27th, 2025, 9 a.m. That is before Judge Washington. Bond will continue. Thank you. Let's call the case of the people versus Frank Clark.
Okay, I'm sorry, Your Honor. I apologize. You can call that previous case. Apparently I wasn't clear,
Okay.
if you don't mind.
You weren't clear? Okay. I guess, can we get him back?
If it's appropriate.
Well, hold on a second, because I lost Mr. Burgess.
I can call you, Your Honor.
Okay, so when he appears, we'll get him back out at some point.
I'm in the court. I'm in the court.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Clark, who's in the court.
Yeah. Thank you, Mr. Clark. Court recalls case, people versus Jeffrey Murphy.
Franklin has the prosecuting attorney about people.
Good morning, Your Honor. Again, may it please the Honorable Court, David Burgess on behalf of Jeffrey Murphy.
All righty. Thank you for coming back, Mr. Burgess.
Yeah, of course,
Yes.
Your Honor.
Thank you, Your Honor, for recalling the case, and thank you to Mr. Burgess for jumping back on. Mainly, I want to make sure the defendant's not confused about how this process is going to work and what his bond conditions are. The victim was present here today in the gallery, and defendant decided it was a good idea to mean mug her as he walked by her. Here.
Sir.
Now, I know that this defendant has a history of abusing women sexually and physically, and apparently somewhere along the way, he has learned and decided that intimidating a victim of his crime is a good idea. Like I said, I think he's confused, so if we can clear some of that confusion, I would appreciate it.
All right. Sir,
Whoa, things just took a dark turn. The defense attorney's casual tone disappears as the prosecutor accuses the defendant of mugging or intimidating the victim right inside the courtroom. For context, that's not just bad behavior. It's a potential contempt of court issue, and could lead to new charges for intimidation or harassment. Judges take this very seriously, especially in cases with prior allegations of abuse. The courtroom is supposed to be neutral ground, but moments like this remind us how emotions can override judgment. If you were the judge, what punishment would you hand down for this kind of courtroom stunt?
understand that? That you're not, and when the court is saying no contact, no intimidating or threatening behavior, that applies both here in this courtroom and all of your behavior. You understand that, sir?
Yes.
And so if the alleged victim is present in the courtroom, I don't want you staring at them any kind of way.
I got you. I apologize.
All right? All right. Thank you. Thank you,
Thank
Mr. Burke.
Yes, of course, Your Honor.
Sir, oh, two in a row.
Chairman Dadush, on behalf of Mr. Serbo, who is approaching.
Your name, sir?
Romeo Serbo.
Thank you.
Your Honor, we are going to be asking for an adjournment for mitigation, and we would like to address bond, please.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. I need a green sheet and then that's bond.
As to bond, Your Honor, I wanted to address, I wanted to ask for him to be released on tether. Your Honor, Mr. Serbo is 20 years old. He has 2 children that he takes sole custody of. He has to take care of them right now. They're in the care of his father and his foster grandfather and foster grandmother, who aren't able to actually keep taking care of his children. He has been in school. He has a 4.0 GPA. He just got his transcript back. He had a job interview. He's doing really well. The reason he was missing them is just because he had so many things going on. They were early in the morning. He has these 2 kids. I can assure you that if you put him on a tether, Your Honor, that you will be seeing obviously no mistests, but no positives or anything like that. He is not drinking. He doesn't drink. He reacts very poorly to it. So we are going to be asking for that.
Yeah, but he wasn't testing on his SoberLink device. I mean, he just wasn't testing like he should.
Yeah, there's 2 that he missed. He was in custody for those. Those are the first 2 missed ones on the report from March. And then he had 4 missed ones, but he submitted a compliant test like within 15 minutes.
I'm talking about, I got that, but his April 24th report from Community Corrections.
I'm not in receipt of that. The last one I have is as of April 23rd. I may have missed it, but
April.
The report that I have, the last test on there that was missed was the 23rd of April. Let me look.
Right, but do you have, there should be a bond violation report from April 20, that's dated April 24th, 2025.
Oh, this is the one. Oh, no, sorry. Yeah, April 24th. This is the same one that I'm looking at.
Okay.
Okay.
Go ahead.
Yes. As 2 of those were missed when he was in custody elsewhere. 4 of those he missed, but he retested like within 20 minutes, 15 minutes, 7 minutes after the 9 a.m. block. I believe there's only 2 that he missed that he never retested for, and those were the newly added time window. I believe he had either forgotten about those, and I understand that that's not an excuse. He just has a lot going on with school, with work, with his 2 kids, and that's why I believe having him on a tether would resolve this issue. He should have been put on tether from the beginning, honestly. But if Your Honor releases him on that tether, and he's not missing any of his drug tests. So,
Any response? Okay.
The only thing I'm concerned about was in September of 2023, the defendant was placed on probation in the Oakland County Circuit Court on 2 counts of RIO and A&B or HIDA. And obviously this offense occurred in June of 2024. So it would have been while he's on court supervision, Oakland County Circuit Court on a similar charge that also falls regarding the defendant's ability to cover.
Your Honor, he is undergoing mitigation for mental health concerns that we're going to provide to prosecution. I've talked to his attorney in his Oakland County cases. He is on probation for those. He's testing in so many different places for so many different things. That's why also he is having trouble keeping track of these tests. And I mean, again, I believe a tether would help with all, huh? What do you want to say?
I just want to tell him that I did ask when I realized it was going to be a problem. So I won't have any problems with it.
Yeah. He's saying that he requested, well, he wanted a tether in the first place. And
when you're saying a tether, you're talking a scram tether?
Yes, sir. And if I was to get that, I wouldn't have any problems. You wouldn't hear it from me. I don't drink alcohol. There's no alcohol in my household. It's just 2 children, and I go to school every day.
2 children and some pot, right?
Well, I smoke outside the house, and it's never around them.
Okay. Do you have a card?
Yeah, I do. And
did you give us your card?
I offered to give that to community corrections, but they refused to take it every time I offered it to them.
And his father submitted it. They'd already submitted it to community corrections. I don't know why community corrections lost track of it, but I talked to his father yesterday, and his father said that he sent community corrections a copy of it again yesterday, but that every time he goes to test, he has his medical marijuana card on him and it's active. And I can send that to the court right now.
I will.
And there you have it. 2 cases, 2 defendants, and 2 very different paths through the justice system. One walked away with a warning and a strict no-contact order, while the other faced probation concerns and left the courtroom with a tether requirement. These hearings show how fragile second chances can be. One misstep, one missed test, and freedom can vanish instantly. So, what's your take? Are these rulings fair or too forgiving? Let us know your thoughts below. And if you found this breakdown as eye-opening as we did, don't forget to like, share, and subscribe for more shocking courtroom moments and legal deep dives every week. Welcome back to the courtroom, where justice meets real life and excuses meet reality. Today's case, People versus Jane Martin. What starts as a simple probation hearing quickly spirals into an emotional backstory of loss, struggle, and responsibility. Jane, a single mother of 5, stands accused of failing her probation terms. No payments, no classes, no check-ins. But there's more to this story than meets the eye. Was it neglect or survival? Let's dive in and see how this courtroom handles compassion versus consequence.
Ms. Martin, please state your name again. Johnny Martin.
Chris Moyer on behalf of probation. Your Honor, Ms. Martin is before the court for a violation of probation hearing. Ms. Martin has been on probation for 2 years for a reduced charge of assault and battery. In this case, Your Honor, Ms. Martin has made no payments to the court. Her balance is $1,530. Probation has failed to receive completion of the CPS Family First Program and Parenting class. Ms. Martin also failed to report to probation after April of 2024. And Your Honor, her probation term is maxed in this case. Given that these items were not completed, probation is recommending that Ms. Martin serve 93 days in jail with credit for 1 day served, that she served the balance, waive remaining terms, accept the financial obligations, and discharge her from probation.
Ms. Perry.
Your Honor, I was able to speak with Ms. Martin about these issues. She believes that she did complete the CPS and parenting class. She's been trying to get in touch with them for the last week or so to get proof of that. She has called the case manager that was on the case. She no longer works there. She gave her another number at CPS. They told her they would call her back. It's kind of she's been, thwarted by bureaucracy. So I'm asking to adjourn this hearing out a bit so she can continue working on that. Again, she remembers completing it, but it has.
Why didn't that information get to probation?
Frankly, Your Honor,
I can tell you why, because she never reported to probation.
She did. That is the allegation, Your Honor. Around the time that this was all happening, the father of her two youngest children was killed in Washtenaw County. And I think she's a single mother. That kind of, greatly affected her life. And she's been dealing with the repercussions of that since that happened in June of 2023. So she wants to get proof to probation. She's just having trouble doing so.
What about payment? I have no payment. I have no reporting to.
This moment right here hits hard. You can hear the exhaustion in her voice. 5 kids, grief, financial pressure. It's a lot. But the judge isn't wrong either. The court can only go by what's on record. Without proof of progress, the law sees non-compliance, not hardship. It's a brutal reality many defendants face. Life's chaos doesn't excuse legal obligations. Viewers, how would you handle this? Is the court being too harsh or just doing its job?
Probation. I have nothing.
I just started working out. She has 5 children?
Yes.
5 children, 11, 8.
11, 9, 8, 3, and 1.
So she, for a long time, didn't have childcare to care for her children and work.
I just started working. I can't make a payment when I get my check.
How come you didn't report to probation?
I don't know. I had after my child's father passed away at my apartment complex, I just shut down. It was real hard on me.
I get all that, but I guess the last time you were before the court was in February. You're going to pay the fines and costs by March 3rd. No payments. You would report to probation. No reporting to probation. I'm assuming you were supposed to complete the Family First program and parenting classes. I don't have any proof of any of that.
Yes, I completed it. I went to Orchard's Children and Family Services. I think that's what it's called.
When?
I finished that class in 2023. I just didn't report it.
So you're saying that was completed before I sentenced you?
Yes.
Runner, I can try to look to see what the prosecutor's office may have.
What
I
the
do not-
prosecutor's office may have?
Yeah, I mean, maybe it was provided to them to reduce the charge, as this charge did originate as a child.
Anything else from anybody?
Nothing from me, Your Honor.
Do you have anything else you want to tell the court?
I would just give me some time to like make the payments. Like I'm all my kids got, like I don't really want to go to jail. I'm already have.
Should have been keeping in track with probation.
Right.
You just didn't do anything.
I know that I did the, I know I did.
Okay, so here's what I'm gonna do. I'm gonna waive the remaining terms except for financial obligations. I'll discharge her from probation without improvement. What I am gonna order is that she's to serve 93 days in jail. I'll give her credit for the 1 day. She's to serve the balance. I will strongly consider release if I get proof of completion of that class. All right, you're still going to owe the money. You need to set something up with the court. You're going today, but if they get me.
And there it is, the final ruling. 93 days in jail with a chance for early release if she proves completion of her parenting class. The judge walks a fine line between accountability and mercy, reminding everyone that excuses don't erase obligations. This case perfectly shows how personal tragedy collides with the legal system, and how proof can make or break your freedom. If you found this case as thought-provoking as we did, make sure to like this video, share your thoughts below, and subscribe for more real courtroom breakdowns where justice and humanity meet head-on.
I mispronounce your name every time, sir. It's okay. I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference regarding.
Welcome back to the courtroom, where truth and panic collide. Today's case, People v. Cyrano Johnson. A man accused of violating bond by drinking alcohol. But here's the twist. When caught, he tried to hide behind a non-alcoholic beer excuse. Judge West isn't buying it, and what follows is a masterclass in courtroom honesty, or the lack of it. Will Johnson's apology save him from jail, or will the lies finally catch up? Let's find out.
Before imposing any sentence regarding that, I'm going to ask this question. He presumably, he has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
the story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had duels. To get to the level that you were at, you would have had to have 25 duels in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He's here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really? No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem. The way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Address bond, Your Honor.
Well, what are we going to be doing on the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper cause.
Yes, Your Honor.
I'll give you a date moment, depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today, along with my
do see you.
My client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But and I'm
not candid would be an understatement. I mean, he just outright lied.
Well, I wasn't there.
That makes it no less a lie.
I'm asking you if you want to hear from him.
I'll-
A humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and you.
Now, this is the part where many defendants break. That moment when excuses collapse under pressure. You can feel the energy shift as Johnson apologizes, but it's not just about drinking anymore. It's about trust. The judge's frustration isn't personal. It's procedural. A court's integrity depends on honesty, especially when a bond violation is at stake. Notice how Johnson keeps referencing panic? That word tells us everything. A man cornered by his own choices, trying to rewrite his story in real time. But will remorse outweigh deception? If you were the judge, would you believe this apology? Comment below.
And when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so did you have any O'Douls?
At first, but
At first. Okay. How many O'Douls did you have? Six. And then you had how many?
Labatt's about four.
Four.
Sure.
Okay. Now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had six O'Douls. I told you to get to the levels that you were, if you were just drinking O'Douls, because you were insistent on that, you would have had to have a little over a case of O'Douls. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had two beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. It's trying to go to treatment.
Well, okay. Yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the last.
Did you or did you not tell me that you were
wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting, trying to go. Yes. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Doul's.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment.
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're
Oh,
working
I
it
know
out.
they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance. And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yeah.
Anything from the people?
Your Honor, people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person. At no point have we alleged that. We're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think without treatment that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm going to do. I'm going to first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at.
Now this is the part where many defendants break. That moment when excuses collapse under pressure. You can feel the energy shift as Johnson apologizes, but it's not just about drinking anymore. It's about trust. The judge's frustration isn't personal, it's procedural. A court's integrity depends on honesty, especially when a bond violation is at stake. Notice how Johnson keeps referencing panic? That word tells us everything. A man cornered by his own choices, trying to rewrite his story in real time. But will remorse outweigh deception? If you were the judge, would you believe this apology? Comment below. And that's the final ruling. Judge West gives Johnson one last chance. A $25,000 personal bond, a 24/7 alcohol monitor, and a strict 10-day deadline to enter treatment. Miss that, and it's straight back to jail. This case shows how fast a small lie can spiral into major consequences in court. From the O'Douls' defense to a desperate apology, Johnson's struggle became a real-time lesson in accountability. It's not just about breaking the law, it's about breaking trust. If you found this case as revealing as we did, don't forget to hit like, share your thoughts below, and subscribe for more shocking courtroom breakdowns every week.